Hello, good morning, good evening, good afternoon. It is a great pleasure, great honor and privilege to be able to have a dialogue with Professor Julian Lew today. Professor Julian Lew doesn't need any introduction for those who work in the international arbitration setting. Professor Julian Lew is, I can just mention that he is the head of the School of International Arbitration of the Queen Mary University of London. He is a top arbitrator, top counsel, top academic professor, and a top human being. It is a great pleasure to have this opportunity to chat with him today. Professor Julian Lew, I know you are 6 hours ahead of me, so good evening and welcome to Canal Arbitragem, arbitration, which normally creates the program to discuss issues, topics of arbitration and international arbitration. Good evening, Professor Lew.
Good evening, Mauricio, and it's a pleasure to be here and an equal pleasure to see you. We go back a long way together as both friends and colleagues. So I'm very happy to be talking with you. And also, thank you very much for your very generous introduction.
Thank you. Professor, since unfortunately, our time is limited, so let me start from the beginning. So you are a top arbitrator, top everything we can imagine. But let me ask you this. How, when, where, and why did you start your career in arbitration?
Well, maybe I can deal with it by just ignoring the word top, for whatever that means. The subject I really enjoyed more than anything else when I was at university was private international law. That was the basis of trying to understand in a given situation, there is an international element, and the first question is, how do we determine what law governs that particular situation? And that can apply across the whole social board, from family relations, commercial relations, business situations, and a certain amount of political actions between countries. So that was my first interest. And when I finished university and I qualified as a lawyer, I went to study first at the Academy of International Law at The Hague, and then went on to do a PhD in private international law. And where I was lucky, the subject that I did at that stage was fundamental to arbitration. How does an international arbitrator determine the applicable law? Now, of course, we know how a national court does it, because in every national court, in every jurisdiction, you have a law of conflict of laws or private international law, and a judge in a national court looks to his law or her law. What do you do as an arbitrator? Because you are not a judge, you don't necessarily belong to a particular country or jurisdiction for the purposes of your appointment as an arbitrator. It's a bigger question, but how do you determine that applicable law? And that was what really got me into the subject when I first started.
Interesting. And if I can fast forward a little bit your history movie and go up to 1985, where the School of International Arbitration of Queen Mary in Westfield College by then was created. I remember as a student, 1992, 1993 students, one of the characteristics of the school, the teaching, was comparative law. How I remember the classes with students from all over the world discussing applicable law on the merits and the lex arbitrae, etc. So since I mentioned the School of International Arbitration, and since it has been there for more than 36 years, can you just tell us about the history, developments of the SIA, please?
Well, the school was started largely by me, but with the support of a very remarkable and very brilliant professor by the name of Roy Goode. Professor Roy Goode is a renowned commercial lawyer and one of the most distinguished people in this country. And at that time, he was the founder of the Center for Commercial Law Studies as a postgraduate unit. And what he was looking for was subjects that were standalone subjects, which could be dealt with at a postgraduate level and within the context of Queen Mary. I was talking to him about arbitration and what he was doing. And he accepted the idea that it is a standalone subject. Now, in many countries, even today, there's still a few countries that consider arbitration to be a domestic subject. Because if you're in whichever country you're in, it's the local procedural rules that will follow. Maybe there are special rules for arbitration, but that's what happens. But in an international context, that can't be right, because the parties have different expectations, they come from different places, they come from different legal and cultural systems, they have different expectations. And that's what the arbitration system has to aim at. And so what we tried to do with the school, and we've enhanced that over the years, is to show that the systems in the common law world and the civil law world and the other systems all are very fine legal systems and dispute resolution systems. But when you're in an international situation with parties from different places, you're looking for I was going to say a compromise. It's not really a compromise, but it's something which is alternative to that. And it's not always appropriate to follow typically common law rules or typically civil law rules, because that's not what the parties wanted. And we should never forget the fundamental, perhaps the most important fundamental rule of arbitration. You only get there because the parties have decided that's what they want, at least in the commercial area. Investment arbitration is slightly different. But the parties have decided to go to arbitration, therefore it's their will that controls the process.
Correct. Yes. And I could see that in person back in 1992. Since you've mentioned Roy Goode, Professor Lew, in 1985, you edited a book which brought some of the luminaries by that time, and also there are some words of Roy Goode in 1995, and he said, I quote, "We must be in a way to create this school in order to foster this debate in international arbitration." And then he said, "We must be concerned with practical questions such as speed and efficiency of arbitration proceedings." This was back in 1985. And we are discussing this today. Exactly. This is a very updated statement. Did we, as members of the arbitral community, the entire arbitration community, did we somehow fail that we still discussing speed and efficiency of arbitration proceedings?
Well, we didn't always. I don't think we achieved that particular success that we had hoped for, but in the international context. But there was another statement that was made in 1985 at an inaugural conference by Professor Pierre Lalive. And he said, to be a really good international arbitration lawyer, you need certain skills. One of those skills is comparative law. You should be a good lawyer in your own jurisdiction. You should understand international law, public international, private international, and comparative law, so that you do not automatically presume that a foreign system is not not good enough for your own system. Now, within that context, what has happened is that arbitration has become such a big subject, not only commercial, but also investment over the last 2 or 3 decades, that more and more lawyers are becoming involved. Many, if not most of the big law firms have large departments specializing in international arbitration. And many of them are based in the United States and in the United Kingdom, or head offices are there, and therefore they're influenced by those factors. And so you get pleadings, which are sometimes written for the lawyers, and sometimes, in my view, sometimes written for the client, but not always identifying the real issues and helping the arbitrators. Because at the end of the day, it's the arbitrators have to make a decision. Lawyers are more concerned about making sure that all of the arguments are presented to the tribunal that they can consider.
Yeah. So this leads me to one issue regarding a good international arbitrator. So you have already mentioned one component, but can you just go a little bit further? What are the most important characteristics of an international arbitrator?
I'm not quite sure there is a clear, definitive answer. But I think there are 3 things that are important. As I said, I think it's an understanding of the internationals, and not just comparative, but different cultures, at least being open-minded towards different cultures, because people do things differently where in different countries and under different systems. But I think that another issue, which is wrapped into that, is also one of tolerance, understanding, willing to listen rather than to be immediately judgmental. Now, a lot of that takes place in a private context of when one's reading a pleading or when one's reading the documents, trying to understand where a transaction or where a situation went wrong. Why did this dispute arise? And one has to be able to work that through, understanding that the parties have come from different situations. It may be that one party is totally responsible and the other isn't, but there's often a situation where things have gone wrong. And it may not be cut and dried. One has to have the patience to listen and hear that. And I think in the third situation, one has to be willing to sometimes to take hard decisions, which are not easy, but decisions that reach a conclusion so that the matter comes to an end.
Yeah, that is interesting. I think this cultural aspect is very important. At the end of the day, counsel has to convince the decision maker. And in order to convince the decision maker, the counsel has also to understand who his or her audience is. I can see, based on my experience, civil law, common law, Latin America, United States, etc., I can see sometimes some differences language-wise or linguistic-wise. The way you write, the way you use passive voice, active voice, sometimes it has some impact in the mind, the process of understanding of what counsel is trying to say. So I think it's very important to understand your audience. You've mentioned tolerance in hard decisions. And this is something that being tolerant, in which circumstances do you think an arbitrator could and should be tolerant? In which circumstances do you think an arbitrator should or couldn't or should take hard decisions?
Well, I think an arbitrator has to try and keep the dispute mechanism going ahead in a particular case. And the tolerance is there may be different situations, depending on where the party comes from, where the lawyers come from, where their clients are, where their witnesses come from. Might not be always as easy to get to see witnesses, to collect evidence. And that's where I mean tolerance of being willing to have a degree of flexibility to help allow parties perhaps more time that may be necessary in other situations. So I think that's where the tolerance is. But ultimately, when showing that the latitude that is necessary, sometimes one has to say enough's enough, because otherwise the arbitrations go on and on and on. Takes you back to the Professor Goode statement that you quoted. Ultimately, one has to bring the procedure to a close at some stage.
So then let me put it this way: you have a tendency to give counsel the benefit of the doubt. Meaning, I understand that you do not are familiar, or at least you digest this. Counsel may be not well familiar, therefore there is some situation that is not very helpful for the speed of the proceeding. But if this continues, then it's a time to stop. Is it more or less a good summary?
No, I'm not sure it is. I'm not sure that is the problem. The problem is slightly different. It may be that the situation relating to the party, remember the lawyer, counsel, represents a party. And parties come in all different sizes and shapes, from on the one hand a government, part of a government-controlled entity, multinationals, smaller companies. All of these situations exist. And the circumstances in which evidence is collected or kept might differ. And that's where I'm suggesting there needs some flexibility. I think counsel has a duty to respect the tribunal and to help the tribunal, because what they want from the tribunal is a result. Ultimately, counsel would probably like that to be in favor of their client, but ultimately the tribunal's duty is to reach a conclusion determining the issues between the parties.
Okay, all right. Now, your experience as arbitrator, Professor Lew, and you have experience as arbitrator in international commercial cases as well as investment estate cases. Is there any difference being an arbitrator in one international commercial vis-a-vis international or investment estate? Is there any difference of being an arbitrator in one area or the other area?
I think there are differences. I don't think they are necessarily that substantial. Let me just quickly give you a few. I think that on the one hand, you have a government. And whatever one thinks about the government of a state, of a particular state, the state has a responsibility to the people who live within that state. I don't want to get into politics, but country by country, governments run the state. By contrast, in a commercial situation, you have people who have much more autonomy and may not have the same kind of power, because governments will have power. And those feed in to the way the arbitration is conducted. For example, often a lawyer will be able to put pressure on the client to approve something within a time frame. That may not be possible in the case of a government. They may need more time because they've got to get, if you're looking for budget, they may need to get permission from the Ministry of Finance, which might have to go through whatever the way the budget functions in that particular country. If you're looking to have a submission approved in a big company, there will be a general counsel who will have looked at the case, will have its own view of the case, and ultimately will sign off. In a state, you will have a situation where Minister of Justice or Attorney General or the senior lawyer in the country, whatever that title is, will have to take that position, and may even have to take that to the government itself, to a cabinet meeting or to Parliament for approval. So that's where I think there are differences. I think there are other factors that behind an investment arbitration, there's invariably a treaty of some sort, whether it's the ICSID treaty or a bilateral investment treaty, or one of the other multinational treaties, whereas behind and of course there's the commercial contract, which is built in, whereas in a commercial arbitration, you have a commercial arrangement which may be subject to a certain treaties like the New York Convention or other treaties, but there is a difference in the power play. And I think there's one other factor. Most commercial arbitrations will be governed by a national law. There are exceptions. So it'll be the law of country X, chosen by the parties, or if they haven't chosen by the arbitrators. And that is what the arbitrators will apply and decide. Whereas in the context of an investment arbitration, you're dealing with international, customary international law, which is determined by arbitrators. And one of the main differences is that in a commercial arbitration, there is no precedent. Each case is dealt with on its own. In an investment arbitration, there's equally no precedent. But counsel invariably will rely on precedent and develop precedent to persuade arbitrators that the particular argument they're making is justified because previous tribunals have either followed that line or expressed views favoring that line.
I was about to ask a question regarding ad hoc, because I think that there is a challenge for an arbitrator to be appointed in an ad hoc case where his behavior or his position is more active than passive when you have an institution. But since you mentioned this precedent coming from the investment state, let me go to one topic, and I think this is a hot topic of today, which is transparency in arbitration. And I would like to start by asking you, based on one keynote speech you delivered in 2020 at Fordham University. And the topic it's a very, very appealing topic, provocative topic of your keynote speech, which is transparency in international arbitration. Practical value or voyeurism? That's a very, very provocative topic. And that leads me to ask you about where do we go from here? Many institutions are discussing today to have an arbitration less confidential or more transparent. So my question to you then is, what is transparency? What must be transparent? Where do we go from here? Is it important for the development of international arbitration, full transparency, partial transparency, or lack of transparency?
Well, let me answer with a flip. First, let me give you a flip answer. If I want to know something and you won't tell me, then you're not transparent. And that's what we see from journalists, and we hear that from those people who want to know more information. The issue is this. Take a commercial case, big multinational company gets into a situation, it's in a dispute with a partner, could be in the construction area, could be in research and development, could be in the sale of goods, could be in shipping, could be in any area. A dispute has arisen. And the one party says it's the other's fault, and the second one says, no, it's not, we did everything we should. And then somebody out there says, what's it all about? Why can't we know? Why shouldn't we? Why did they appoint this arbitrator? Why did they choose the ICC and not some other system? And why did they agree on English law and not Swiss law? So the people are trying to find out what is going on in the arbitration world. This is a dispute between two commercial entities. And I'd go even further and say when a government is involved, and I know governments are answerable, at least in many countries, to the people, even there might be a time to review what government did or did not do. But why is one looking to be able to review what a government did when there's an arbitration going on. There's an arbitration which is taking place to determine rights and wrongs of the parties. And that has lots of other implications, from applicable law to quantum to ownership of rights. That's what arbitrators have to do with the help of counsel. Why does one need to bring that information to the public domain? And I think that's because people are interested. And they may be interested because, well, arbitration is very interesting. And here you've got a dispute arising between two companies, and maybe it involves the development of a new vaccine for some problem that's going on at the moment. That may all be true. But why should all that information, which is confidential, be come into the public domain? But that's the question that I think is behind transparency. I don't know why everybody wants to know what's going on and why they should be entitled to do so.
So your answer is more a sort of a Socratic answer. So it is an answer with another question: why? Why they should know? I would tend to say because this may help the development of arbitration. It may invite arbitrators to maybe to be more, I don't want to say more efficient, but to be more cautious, more, and counsel also institutions. And don't you think it can help the progress and the development of arbitration with more transparency?
In some ways I do, yes. And in fact, I wrote about that back in early 1980s. And some of my work in my early years was based on decisions of arbitrators. But the question is, why are you looking for this information? There are organizations who want to know more and more about arbitrators. But what is the reason for doing that? There may be good reasons. Arbitrators develop their reputations by experience. People say, well, that is somebody whose judgment I know and whose judgment I respect, or who's got a reputation which is worth respecting. So, and the very fact that the arbitrator who comes from Italy might react in a particular way does not mean that the arbitrator who comes from Costa Rica will react in the same way. And equally, it doesn't mean that the one is right and the other one is wrong. And when you start throwing in other jurisdictions through Asia, through Africa, there are different cultures which influence the way arbitrators and arbitral tribunals react.
Okay, all right. So what about, Professor Lew, what about the topic of arbitrators' appointment? Do you think, or let me put it this way, is party appointed arbitrator at stake, or it represents a well-established right of the parties in an essential phase of arbitration process? In other words, do you think the discussion that we had a few years back between Jan Paulsson and Berg regarding perhaps the leaving for the institutions to appoint the arbitrators rather than the parties, is this something that you see as something that is coming, or it goes against one of the fundamental rights of the parties when they decide to go to arbitration?
Well, let's go back where we talked about much earlier. Why are we in an arbitration? We have an arbitration because there's a dispute and the parties agreed to go to arbitration. They didn't have to. The countries they came from, well, maybe they don't have honest and decent courts, but most countries do. They could have gone to a neutral court. They have chosen to go to arbitration. And one of the attractions is because each party can choose an arbitrator. Now, there are situations where they don't choose an arbitrator, or maybe they even will want something specialist. If you wanted an arbitrator, and you don't know, you want an arbitrator who has great knowledge of a particular situation, whether that be in an industry context, you don't have that information to hand, and maybe there you do want 3 arbitrators to be appointed. Do institutions always get the right people? They try very hard. They have great sources to make sure they know people with different kinds of skills and different levels of experience. But ultimately, to win the confidence of the parties, the arbitrators need to come, I think, can earn the confidence of the parties by the fact that each has contributed to putting together the tribunal, not only by nominating an arbitrator, each one nominating an arbitrator, but also by directly or indirectly influencing the choice of the 3rd arbitrator. That might be, even if the appointment is then made by an institution, they're giving an indication of the kind of individual, the kind of experience, the kind of knowledge they would like that presiding arbitrator to have. Big question is, which is often talked about, does the arbitrator have to be a neutral national? Objectively, probably not. Most people would be quite open and fair and reasonable, even though they may be the same nationality or the parties. But that's not what the parties think. Parties have insecurities, and that's why, in the main, they would like somebody who's got all the right competences and is not of the nationality of the other party.
Mm-hmm. Talking about insecurities, Professor Lew, let me go then to an issue of the duty to disclose, or duty of disclosure. It has been subject to many discussions and conferences and webinars, and this topic of disclosure. There is a duty. An arbitrator has a duty to disclose any facts that may impact his or her impartiality and independence, so on and so forth. The IBA has the colorful list, and so on and so forth. How far can we go, or how far can or should the arbitrator go when he or she is asked to disclose issues that may affect or impact his or her impartiality or independence? And what is the duty, or what is the burden, if I may say so, of the parties, counsel, in order to be more transparent in what may be situations that can lead to possible conflict? What is your thought? What are your thoughts about this issue?
Well, most disclosures are, I think the most obvious disclosures never come out, because when you get something and it's quite clear there's an important disclosure, you don't accept the nomination. I'm sorry, I can't accept, for whatever reason it may be. So therefore, when you are making a disclosure, it's because there's something out there that the arbitrator considers might be of relevance to the party and should make that disclosure. Now, how far you go is an interesting question, and many arbitrators have their own view. Some go much further, and some say, well, if I don't think I've got a conflict, I don't think I need to disclose that I know somebody. The old story about I went to I'm a member of a tennis club. I know you're a fan of tennis, and there's one of the parties, the chairman of one of the parties is in the same tennis club. I've even played tennis with them. Do you need to disclose that? It's got nothing to do. It's not a friend. What is a friend, by the way? Is a friend somebody who you meet up at a conference and you very much enjoy having a beer together and talking about about your practice? Or is a friend somebody you're going to invite to your child's wedding? You go to their home and they come to your home. So what is a friend? And even if you have a friend, does that really affect your judgment? Well, if you're that close, maybe one of the parties would like to know that you've been to to the arbitrators being to counsel's home or to the party's home, and vice versa. So I think that, for me, many of these things are self-evident, but it's really the parties that you're trying to, they shouldn't receive something and think that something is being hidden. And I think there's one other thing. You asked the question, what's the position of counsel? For most times, I think counsel are totally objective. Do we believe that this arbitrator, despite this disclosure, is fine and impartial and objective and independent? We don't have to worry. Or is counsel saying, well, maybe this is an opportunity for me to try and control the tribunal, get rid of that particular arbitrator, maybe bring somebody else in. Maybe this arbitrator is too strong, or maybe they haven't liked the way the arbitrator has been appointed. It can be misused by counsel because it becomes a tactic.
Yeah.
And I think that's a risk. And the question is, and I leave it in the air, I'm not sure we'll have time to discuss it tonight. The question is, what is counsel's obligation throughout the arbitration? Counsel knows that when they appear in the national court, they have certain functions and responsibilities to the court and to the judge under the law and the bar rules of that country. But when you are involved in international arbitration, where three arbitrators from different jurisdictions, and there's a fourth neutral venue where the arbitration has its seat, and the parties come from other places, and counsel comes from either a totally different country, or for that matter, from a multinational law firm, what is the duty to the tribunal? Is there a duty?
Yeah.
And I will say this, I have seen counsel say things and behave in the tribunal where they would never do in front of a court. So they obviously feel a little bit freer.
Do you see this more often lately, or this is something occasional?
I've seen it more often in recent years.
In recent years, yeah, that's true. Yeah. This topic is
The IBA have been looking at this to try and develop a set of rules which should have some influence and application for international arbitration.
Right. Yeah, I think this. I think there is an obligation. There is an obligation on counsel to also to disclose affiliates or any parties which may be somehow involved, key witnesses, so that the arbitrator, the potential arbitrator, does not need to investigate deeply. So it is a sort of a good faith, I would say, from the arbitrators to disclose what he or she knows and he or she feels uncomfortable with, and duty or obligation from counsel side. And also there is one aspect from the institution to create some sort of a list or include in those traditional questions that the arbitrator has to answer, some also be in a more proactive way in order to help avoiding this tactic that you've mentioned a couple of minutes back. Talking about counsel, Professor Lew, what is a good counsel in international arbitration? How do you want to see a good counsel, or in your experience, what you have seen as good counsel, good advocacy, or bad advocacy, or ugly advocacy in international arbitration?
Well, I find that's a very big question. I'm not sure I can answer it simply. But I think the counsel needs to, what do I want at the end of a hearing? What do I want before the hearing? I like to, before a hearing, have read what the case is all about. I like to know that. I want to read the evidence. Keep it simple. Tell the arbitrator the important things. Put all the information in there, but give them a way to get into this case, to understand the case, Because once you've understood the case, you can understand the claims and the defenses, and then helps you to get to the conclusion you need. Now, so often, counsel will bring up issues that frankly are not fundamental to the main issue in dispute. It'll be other issues which are peripheral to the relationship between the parties. The relationship between the parties has broken down. But the arbitrator wants to know, what does this particular clause mean? What actually happened when the contract broke? What was the real technical difficulty in the problem that cropped up, and who was responsible for it? And that's what the tribunal wants to understand, because that's what it's got to work through and reach its conclusion. Frequently, other issues come out. We know that the relationship's broken down, and there's a lot of angst which exists, and I remember that from my own days as counsel, a lot of angst which exists between the parties because their relationship has come to the end.
Interesting. Professor Lew, is there any specific a piece of advice that you could give to the young generation? So we can see today, I would say, an explosion, or maybe an expansion or an explosion of arbitration or international arbitration in the world. And with that explosion, we can see more users, more players, and among those players, we see parties, arbitrators, counsel, and there is a young generation that is coming through. Is there any specific piece of advice that you could give for the youngsters?
Well, of course, all these young people you're referring to are coming from different places. I think one of the things that does help them in the arbitration world, I'm very proud of the fact that we set up the School of International Arbitration in London. And for 15 years, I think we were the only institution actually providing postgraduate studies on a structured way. Of course, today they are being taught all over the world in many excellent places. And of course, you're one of the professors in that area as well. And I think that is a great advantage for students. And if you go to one of these, they go to one of these colleges, not just to benefit from the learning within the context of a course, but also the fact that they meet other young lawyers who come from diverse countries. It's part of that cultural learning. So they've come from, somebody from Latin America meets people, different places in Europe, different places in Africa, different places in Asia. And all of a sudden that broadens their understanding, not just of law. So I think that's my first point. I think the second thing is that they should have a real understanding of the areas of law that are fundamental to international arbitration. And as I said earlier, said by Professor Lew, getting on for 40 years ago, comparative law, private international law, public international law, a very, very good understanding of those. And of course, a thorough understanding of the law in which that individual is qualified. So wherever you come from, as you know, when you've been practicing law, unless you're in a very specific area, it's being able to analyze a problem, which every lawyer has to do. And you learn that from experience and by falling back on the general principles of law that we all learned in our first couple of years at law school. And when a lawyer has developed those skills and hones those skills, that gives them the basis on which to develop their practice. And I hate to add this as a final, because it's not a very positive thing. There is an element of luck. Getting into a law firm or into an institution where they would gain experience, see situations, be part of a team. One of the best places to be in a team in an arbitration is probably the bottom junior person, because you see everybody from the senior through the levels, which is where the young lawyer wants to go. And that's where you learn. You see what other people are doing, and you make your own minds up. You see so many good practices, and some which you may not believe are the right things. And that's how the young lawyer hones their skills.
Fantastic, fantastic, remarkable comment. I would add, if I may, the role of those moot competitions. I can see today the level of students who participated in those moot competitions, pre-moot or the Vis-moot in Vienna. They are much better than I was at their age. And this is what we can say a true development of arbitration. I'm very, very pleased to see these young generations, the way they behave and plead before an arbitral tribunal, although it's a moot competition. Let me turn on to some challenges, Professor Lew. And one is, I wouldn't say, I'm trying to create a sort of a positive or not so positive. But perhaps this is a wrong depiction of what I want to ask you. One is, we can see, as I mentioned before, this explosion of arbitration nowadays. And we are all celebrating that. Can we say this because of those challenges that the quantity creates by itself huge amount of lawyers, arbitrators, parties, etc.? Can we say that the golden age of arbitration is gone, has gone, or are we going to be too romantic saying that, or it's just a new era of arbitration that has just begun? This is my first question. And the second one is the role of, and perhaps this would require more time, but because of this huge amount of quantity in cases and players, etc., do you see a need for a greater support and better understanding of the courts, of the judiciary? In other words, do you think that the judiciary is following this development, this increase of players in the market, or some decisions that we can see here and there is a testimony of something is not as they are not going on the same path, same direction?
Well, there are two questions there which are very different. And I think there's a third question which you didn't mention. And the first question is the golden age of arbitration. I don't know when the golden age is. Maybe golden age is when each of us as an individual is really motoring and enjoying their practice. And when things develop in a way that is more difficult, or when it becomes more aggressive, or when it becomes more focused, we kind of think, oh, things are changing, and not for the best. It's a little bit like as we change from doing everything on paper and then becoming electronic. And then as soon as you become electronic, there's some more efficient and quicker way of doing it. And I find I work with so many of these young lawyers, and they're brilliant. The way their speed of handling the electronics, and I'm pretty good at that, but I'm slow in comparison. So what, is that golden? Is it more golden, or is it not? I don't know. The question is, and I think an important way, is arbitration providing what the users want? And now the users are not lawyers. Very few of them have been to Queen Mary or elsewhere. The users are the business people who've made a deal, made an investment, and something has gone wrong. They're the ones who've chosen to go to arbitration. And they're the ones who have to decide, are they getting from arbitration what they want? And if they don't get what they want, just like where they choose their customers, and frankly, they choose their law firms, they don't get what they want from arbitration, they don't find it reliable, they don't find it efficient, they don't find it, if they find it overly expensive, they will talk with their feet, both in the choice of lawyers and in choice of arbitrators and in choice of arbitration system. So that's, in my view, of the golden. The golden is not for us to judge today what was golden. We will see, because the users will make that decision. As for your second question about the judiciary, I think that in early years, many judges, and again, how many countries? We're talking about over 200 countries around the world, all of whom have had judiciary. And in different ways, the judiciary, judges, are appointed by the state through the legal system of the state. They're important people in the state. Their role is to uphold the law. Their role is to get things right if they possibly can. Their role is to do justice if that's what they can do. And that's their position. And as I say, in most countries, maybe more efficient or less efficient, you have pretty good legal systems, because those judges want to do it right. That's not the basis of an arbitrator. The arbitrators get involved because the parties have chosen arbitration. You have a much more direct choice of arbitrator. We have a choice of which institution or ad hoc you're going to. All of that gives much more say to the parties. Now, if you are trying to take a case to a court, a judge might naturally say, well, who are these people, the arbitrators? I, Mr. Judge, have been appointed by the law in the state I come from. Who is these arbitrators? Who are these people who've been selected by the parties? Who is this institution? Now, I think that was a case where we found in many countries judges would get involved. I think that's changed, and it's changed for three reasons. First of all, I think judges have begun to increasingly understand that parties have opted out of the court system, and there are limitations, of course, of the extent to which you can completely opt out, and will respect the choice of the parties for that purpose. That's the first thing. The second thing is, I think many judges now see the opportunities for themselves when they retire as being judges of maybe doing a little bit of arbitration. It enhances the pension, and many of them are very, very good. They're not always as international as one would like, but they are good, they're judgment, good lawyers, experienced people. So I think that's another factor. And then the final factor, and most important, is the conventions. New York Convention was the cornerstone, going back to 1958. Now, was it 161 countries party to the New York Convention? That's quite a phenomenal situation, that you, in principle, should be able to enforce your award or resist enforcement on the same rules in something like 70% of the world. Amazing solution. Of course, it has the counterpoint. It's very difficult to change and improve the New York Convention, because it takes a long time to get 160 countries to be party to it. But in addition to that, you've then got the UNCITRAL model law. UNCITRAL has done a lot of amazing work in trying to bring out the rules, the ad hoc rules, which are used in arbitration, and also in the model law. And that has put down a guide of what many people would accept are basic standards of arbitration. Not to say they're perfect, not to say they're the only ones, but they are a yardstick for judgment. And I think that when you take that to a judge in a court, a judge will look at that and say, well, that's an international instrument, whatever its effect, that's what the parties are wanting. And I think that's helped their understanding of the place of international arbitration.
Yeah, interesting. I had actually a few follow-up questions because this is a fascinating topic, and unfortunately, we do not have enough time to do that, which makes me think that I should invite you another time to discuss this issue, because I think it's a fascinating topic for the current state of arbitration in the world. But let me ask you one, if possible, one or two questions, Professor Lew. One is based on what you said by comment one of my previous questions, and you said something along those lines. The real question is arbitration providing the right tools for the users? And then when I see the latest Queen Mary survey, which has been amazing what Queen Mary and recently with the White and Case are doing for the international community as a whole, the latest one, the 2021 survey, addresses the topic of arbitration to a changing world. So there are many issues regarding technological topics, etc. But my point here is, one statement says 90% of the interviewees responded international arbitration remains the preferred method of resolving cross-border disputes. That's 90%. That's not a surprise to me. However, what is surprising is what comes next. 31% on a standalone basis and 59% in conjunction with ADR, with other mediation or ADR as a whole. So 59%. So people are saying, I prefer arbitration rather than litigation before state courts for the reasons you've mentioned. But then 59% says, I prefer something prior to arbitration. How do you read this?
I can try and give some thoughts about it, but I can't answer the question specifically. I don't remember the empirical work that was done. But what seems to me is this: you know, in every arbitration, I've heard it said there are several winners. The counsel are winners because they earn money from it. The arbitrators get paid. One party walks away invariably or frequently unhappy because they were found to be wrong. And that can be unfair, or at least they feel it's unfair. They're dissatisfied, or they may be. By going to a mechanism of, or trying to settle through the help of a third party, through one of the ADR processes, by trying to do that, when that comes to a conclusion, because that's not an imposed decision, that's something which ultimately you help to get there, and that decision is taken by agreement. Both parties walk away and say, well, I didn't get exactly what I wanted, but I walked away with something. I didn't take the risk that the arbitrators would believe the other side rather than me. And that's what I think parties are saying. They had an advantage in actually settling a case. And if you can settle it, the angst of going before an arbitrator, the time spent with lawyers preparing a case, the costs of the lawyers preparing a case, the turn off in time, if you've got a 3 or 5 day hearing, the amount of effort that the management of a company put in supporting their lawyers, supporting their witnesses, watching what's going on, can take over their lives for a period of time. For witnesses, there's enormous stress going into a case to be questioned by a lawyer who's trying to show that you are not reliable, or your memory isn't very good, or you did something you shouldn't have done, and arbitrators who are going ultimately to believe you or not believe you is very stressful for an individual. Mm-hmm. And that, if you can resolve a matter by agreement, all of those issues go away. And that is an advantage, I think, an advantage for everybody. And I'll just add one other thing. I myself am not a mediator. And over the years, both when I was doing counsel's work, I was involved in a couple of mediations, and since then. But I'm not a specialist mediator. But I can see that if it can be resolved that way, that must be ultimately, in many cases, to the advantage of the parties.
Interesting. This reminds me the beginning of our conversation here, the Roy Goode's statement, more efficient or cheaper. Perhaps parties are looking for something cheaper and quicker. And this, I don't know if this is going to be the case, because sometimes the clause itself does not help achieve that goal. But I understand that this is perhaps an alternative for a quicker and cheaper process. Final question, Professor Lew. Let's assume that we are in the future, 2030, 2040. Let me check your crystal ball. How international arbitration will look like 10, 20 years from now? Any guess?
Well, if you're talking about 20 years from now, I shall be quite an old man, so I doubt I'll be involved, but I'd be very interested to see what the situation is. But I'll give you a couple of answers. I don't know the answer. I really don't know. But whether we're going to have artificial intelligence taking the place of arbitrators, where the parties would feed in all the facts and the stories and the documents, and the artificial intelligence will come up with an award. I don't know if we're going there, but I do think that we've seen in this last 15 months what COVID has done, and the way we are all handling arbitrations, hearings, big hearings, short hearings, deliberations, sitting in different corners of the world, watching a screen as I'm doing now and you're doing now. That has shown. Look how much better these systems already are, in the way you look at these screens now. It reminds me of I have a daughter, as I think you know, who lives in Australia, and I have the opportunity, I had a granddaughter there, and of course, I haven't seen her for a long time because of COVID, but I do remember that every week I would see her, and instantly I would be able to tell if she's in a good mood or a bad mood. She's looking great, she's looking tired, but at the end of the day I could never get a hug. I'm sure that in a few years' time, the computer is going to, when we get to the end of the conversation, have some arms that come out and give us a hug. It won't be the normal human relations that we want, but look what we've got now compared to what we had years ago. Because I remember, again, when I was doing counsel's work, when you would occasionally have a witness, very rare, but a witness would give evidence by video, how often that video link broke down. And if it worked well, you were lucky. And nowadays, very rarely have a problem. I very rarely had a problem, certainly in the last 15 months. So I think we're going to see new technology. But I told, and I'll finish with this, but I was asked the same question about, I know, 10, 12 years ago. And I said the following. We're used to being human beings. We get together. Counsel party comes to see the lawyer, brings a stack of papers and says, here's the contract. This is what's gone wrong with my contract. Here's the correspondence. These are the expert reports, and tells the lawyer. The lawyer gets into correspondence with the lawyer on the other side. It's all paperwork. And in the old days, of course, you sent it by letter. And then we got fax. And now we have documents which go email are there instantly on the other lawyer's desk. And then, of course, the lawyer at the other side would analyze, take instructions and respond, appoint a tribunal. The institution would appoint one arbitrator, the other arbitrator. You'd set up the tribunal would call for a meeting. All of that worked. And I'm not sure it was the golden age you're talking about, but maybe it was. How about this situation? The client is going to have a problem. But the client is not going to go to the lawyer. The client has got all these paper. We're not going to have paper anymore. It's all going to be on the computer. The client is going to get the paper off the computer into this chip, which he'll have behind his ear. And the client will ask the question, not on paper and not verbally, to the lawyer. Say, I've got this problem. And it'll come straight into the lawyer's chip. And it will say, and there's a contract. And that will come into the lawyer's mind, the eyes. And we've had this correspondence that will all be there. The lawyer won't sit there and read it like we do. The lawyer will automatically imbibe it through this chip that's behind the ear. and then you'll go through the whole process. Now, the whole hearing will take place. You might not have a hearing because it'll all be through the chip that is coming. The witness will be asked questions, will know the questions that are being asked, will give it evidence, and it'll come straight through the chip to the tribunal. And the tribunal will communicate and deliberate between the arbitrators through their own chips, sitting in 3 different corners around the world. They won't be faxing or emailing draft awards or draft sections of an award for discussion and deliberation. It'll all be done through this mechanism through this chip. And then they'll reach a conclusion, and they'll have the award, and they'll decide this party's won and that party's lost. And this is what the remedies should be. And they won't deliver it by sending a piece of paper like this with a signature and through the institution with maybe a stamp on the bottom. They'll send it through the chip. Fantastic. I won't be doing that. Here's the one question I can't answer. How are the arbitrators going to get paid?
Cryptocurrency, probably. It's been a fascinating conversation, Professor Lew. Remarkable comments. I'm totally confident the international community that is going to listen to this conversation, they're going to enjoy a lot. I would like to finish by giving you a virtual hug in a way that perhaps in the future is going to be a little bit more personal, a little bit more human. Thank you so much, Professor Lew. And with that, we finish our conversation. Unfortunately.
It's been a great pleasure being here, and great pleasure seeing you. And I look forward at some stage in the not too distant future where we'll actually meet up in person again.
Absolutely. Thank you.
Thank you, and good night.
Bye-bye.